Howdy everybody, this is Trespass My Eyes. I just want to let everybody know if you're looking for files that I talk about, if you go to my First Amendment auditing files, I'll post them in here if they're available in these directories, and you can search for them or just look into your state or local federal. If you have any files you'd like posted, let me know and I'll take a look. If they're appropriate, I'll put them up there for you too. Thanks. Howdy everybody, this is Trespass My Eyes. Hey, I previously did a Chapter 1 on the Ventura County Sheriff's Department open or no, public records request, and I forgot that I didn't talk about the actual law. So I want to go over some highlights on this. First note, I am not a lawyer, and I don't even pretend to be one on YouTube, so for what it's worth. So where you get this stuff is you go to the legalinfo.legislature.ca.gov, and it's broken into sections here. Like if you wanted to look at the penal code, it's down here. If you wanted to look, this one is in the government code. So if you look here, you can see that it says government code. See? So then I'll go to these, bring them up and print them as a PDF and save them. So it makes it easier to print them out or whatever you want to do with it. So let's go over this real quick. So this is known as the California Public Records Act, and in this one they talk about local agency. It's a city, county, whether general law or chartered school district, municipal corporation. This basically, I think it just tells you what it applies to. Okay, a member of the public is any person except a member, agent, officer, employee of a federal, state, local agency acting within the scope of his or her membership. So that, I guess that means normal people can do these requests, but if you're a member of that agency acting within your scope of your job, you're not supposed to use, it doesn't apply to you, the Public Records Act. So down here, here's defines public records, includes any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by state or local agency, regardless of physical form or characteristics. Public records in the custody of or maintained by the governor's office means any writing prepared on or after January 6, 1975. I don't know why they did that. Writing means any handwriting, typewriting, printing, photostating, photographing, photocopying, transmitting by electronic mail or facsimile, and every other means of recording upon any tangible thing any form of communication or representation, including letters, words, pictures, sounds, or symbols, or combinations thereof, and any record thereby created, regardless of the matter in which the record has been stored. Pretty comprehensive. Okay, I'm going to scroll down. Public records are open to inspection at all times during the office hours of the state or local agency, and every person has a right to inspect any public record, except as hereafter provided. Any reasonable segregable portion of a record shall be available for inspection by any person requesting the record after deletion of the portions that are exempted by law. So that would be, like private information, like if you requested a police officer's pay and stuff, you don't get his address with it. You can get his name and his badge number and the specified amount of regular pay, overtime, and stuff he got, but you're going to get much more than that. Except with respect to public records exempt from disclosure by express provisions of the law. So this thing specifies, it has a whole section on exemptions to this, and there's a lot of them, but there's still a lot that you can get under this. We'll call it the CPRA. Each agency, upon request for a copy of record, shall, notice here, within 10 days from receipt of the request, determine whether the request, in whole or part, seeks copies of disclosable public records in the possession of the agency, and shall promptly notify the person making the request of the determination and the reasons thereof, or therefore. In unusual circumstances, the time limit prescribed in this section may be extended by writing notice by the head of the agency. I mean, sometimes you might have to give them more than 10 days. Depends on what you're asking for. But it says down here, no notice shall specify a date that would result in an extension for more than 14 days. I don't know how you hold them to that, but whatever. Here we go down to, this is 6253.1. When a member of the public requests to inspect public record or obtain a copy of a public record, the public agency, in order to assist the member of the public, make a focused and effective request that reasonably describes identifiable record shall do all the following to the extent reasonable under the circumstances. And this talks about, like, when you make a request, the receptionist or whoever's there, county clerk, they should assist you if they can, to help you, because they know more about the records than you do probably, so they might help you make a better statement of what you're actually asking for. So it says assist a member of the public to identify records and information that are responsive to the request or to the purpose of the request. Describe the information, technology, and physical location in which the records exist. Provide suggestions for overcoming any practical basis for denying access to the records or information sought. The requirements of paragraph 1, subdivision A, I guess right here, shall be deemed to have been satisfied if the public agency is unable to identify the requested information after making a reasonable effort to elicit additional clarifying information from the requester that will help identify their records. And when we start down this path, I'm wondering, because it doesn't seem like they do a lot of them, so we'll see how helpful they are. 653.3, a state or local agency may not allow another party to control the disclosure of information that is otherwise subject to disclosure pursuant to this chapter. I guess that means one agency can't tell the other agency to disclose that they can't disclose something if it's supposed to be disclosed. I'm not a lawyer. Here you go. I highlighted may because I like when I see these may or shall. It's a world of difference. So when you see these little nuggets here, try and pick them out. Every agency may adopt regulations stating the procedures to be followed when making its records available in accordance with this. So that means they may have a procedure for their public records request, so they don't have to. And then the following state and local bodies shall establish written guidelines. So since this is a state record or state law, all these state agencies, they're telling all these state agencies in this law, you shall establish written guidelines. So a copy of these guidelines shall be posted in conspicuous public space at the offices of these bodies, and a copy of the guidelines shall be available upon request free of charge. So they can't charge you for this record to any person requesting that body's records. So look, you got a whole bunch of them. Guidelines and regulations adopted pursuant to this section shall be consistent with all other sections of this chapter and shall reflect the intention of the legislature to make the records accessible to the public. Okay, this one talks about petitions, and the information you can get from petitions. Hey, if you need to do this, you can read it. I just highlighted to show it talks about petitions. You can't really get much from them, except like the numbers of them, things like that. Here you go. Persons who have requested bilingual ballots. Well, there you go. That's another part of it. Don't need that. I highlighted this one. Unless otherwise prohibited by law, any agency that has information that constitutes an identifiable public record not exempt from disclosure pursuant to this chapter that is in an electronic format shall make that information available in an electronic format when requested by any person and when applicable shall comply with the following. So it's not like if you're Hillary Clinton and you've got 30,000 emails and you print them out, you have your lawyers print them out 30,000 pages of paper. They can't do that. If you've got electronic records like emails, or even, you know, well, emails is appropriate, I guess, then they have to give them to you electronic format, maybe in PDF form or a searchable database that's got the emails in them. I mean, you can do a PST file if it's Outlook and just limit the PST files to what's available. So you can't tell I'm a computer nerd, can you? The agency shall make the information available in any electronic format in which it holds the information. So like if it's emails, you do PSTs, or a database, you could do a query and print a table. Each agency shall provide a copy of electronic record in the format requested if the requested format is one that has been used by the agency to create copies for its own use. So if they create copies, then they can do it for you. And the cost of duplication shall be limited to the direct cost of producing a copy of a record. And this is, yeah, we'll find out how much these things cost. We'll let you know. The requester shall bear the cost of producing a copy of the record, including the cost to construct a record. So if you got a database and you got to do a query, so they're going to charge you for, I guess, the time to pay someone to do a query, which any database administrator worth his salt should be able to do a query. 10 minutes. It depends how familiar you are with the database. And the cost of programming and computer services necessary to produce a copy of the record when either the following applies. The public agency would be required to produce a copy of electronic record, and the record is one that is produced only yet otherwise. Yeah. This basically talks about electronic stuff. Jeopardize, compromise. Okay, yeah, they can't. They're exempt if the release would jeopardize or compromise security or integrity of the original proprietary record of any of the proprietary software. I mean, you can't ask them if they built a program. You can't ask for the source code. That's not open record. Nothing in this section shall be construed to permit public access to records held by any agency to which access is otherwise restricted by statute. So if there's another law restricting it, then it's exempt. School district here. Okay, let's read here. If a local agency, except a school district, maintains an internet resource, this is kind of interesting, including but not limited to an internet website, internet web page, or internet web portal, which the agency describes or titles as open data, and the local agency voluntarily posts a public record on that internet resource, the local agency shall post the public record in an open format that meets all the following requirements: retrievable, downloadable, indexable, electronically searchable, but commonly used internet search applications, platform independent, available to the public free of charge and without any restriction that would impede the reuse or redistribution of public record, retains the data definitions and structure present when the data was compiled, if applicable. So you see this a lot with PDFs. So as long as a PDF is searchable and it's not just a PDF with an image on it that's not searchable. So if you got a database creating a PDF, or say some kind of form that's in PDF format, it's supposed to be searchable, not just say you make a copy of a freaking form and post it on there and turn it into a PDF and post it on there. That's not acceptable because it's not electronically searchable. If you use the original Word doc, create a PDF, it'll be searchable. That's kind of what they're talking about. So this is talking about exemptions, more exemptions, preliminaries. Here's another one. Notwithstanding other provisions of subdivision, state and local law enforcement agencies shall make public the following information, except to the extent that disclosure of a particular item of information would endanger the safety of a person involved in an investigation or would endanger the successful completion of the investigation or a related investigation. Now, I don't know if they can use this to slow you down if you're maybe doing discovery or trying to get information on your own case that's still under investigation. Let's see. So here's something that Onus News Service talks about. The full name and occupation of every individual arrested by the agency. The individual's physical description, including date of birth, color of eyes and hair, sex, height and weight, time and date of the arrest, the time and date of booking, the location of the arrest, factual circumstances surrounding the arrest, the amount of bail, the time and manner of release, the location where the individual is currently being held, and all charges the individual is being held upon, including any outstanding warrants from other jurisdictions and parole or probation holds. So that's a lot of stuff. Now, I've seen Onus News Service talk about this, and they went into somewhere and got asked for it, and they were asked for their name, and they said it's not required. Now, I can't find it in here where it states that the requester doesn't have to provide their name or ID. So if you know where it's at, maybe it's in here. I don't know. So subject to restrictions imposed, the time, substance, location of all complaints or requests for assistance received by the agency, and the time and nature of the response thereto, including to the extent the information regarding crimes alleged or committed or any other incident investigated is recorded. The time, date, and location of the occurrence. So this is, like I guess you can get radio calls, the name and age of the victim. So that'd be like a 911 call, I guess. Factual circumstances surrounding the crime. Okay, so that tells you about a lot of the police stuff you can get. I'm scrolling down looking for the highlights. These will be, this file is available on my files section. If you know, with my homepage, lower right, you can look. It's in the California law section of my Google Drive that's got the link on my web page. So if you want it, there it is. Well, I'll have it without the highlights. Okay, 6254.4.5a. This chapter does not require this chapter does not require disclosure of a video or audio recording that was created during the commission or investigation of the crime or rape, incest, sexual assault, domestic violence, or child abuse that depicts the face, intimate body part, or voice of a victim of the incident depicted in the recording. And so if in these cases they don't have to release, I guess, body cam, or if they've got video of it from somewhere, of these kind of assaults or crimes. So the public interest served by not disclosing the recording clearly outweighs the public interest served by disclosing the recording of the recording. Okay, more highlights. Okay, you can get open records. Every employment contract between a state or local agency and any public official or public employee is a public record, which is not subject to the provisions of 65.4, 65.5. Computer software developed by a state or local agency is not itself a public record under this chapter. The agency may sell, lease, or license the software for commercial or non-commercial use. Again, like source code on software that they develop. All right. Scrolling down. I don't want this to be too long and boring. It's already boring, isn't it? Brr. Here we go. I might be out of. Oh, there's a couple. So nothing in this chapter shall be construed to require the disclosure by a county recorder of any official record if a public record version of that record is available pursuant to Article 3.5. Oh, I guess it means they don't have to give you the official record if a public record is available. Okay. Nothing in this chapter shall be construed to require the disclosure by a filing office of any official record of same thing as above. Here's this one. A state or local law enforcement agency shall not require a victim of an incident or an authorized representative thereof to show proof of the victim's legal presence in the United States in order to obtain the information required to be disclosed by that law enforcement agency. So I found that, but then down here if for identification per state or local law enforcement agency requires identification in order for a victim of an incident or an authorized representative thereof, sorry, as a lawyer, to obtain that information, the agency shall, at a minimum, accept a current driver's license or identification card issued by any state. So it looks like they're leaving it up to the local law enforcement, the state or local law enforcement agency. A current passport, blah blah blah. So ID. The agency shall justify withholding any record by demonstrating that the record in question is exempt under the express provisions of this chapter, or that on the facts of that particular case, the public interest served by not disclosing the record clearly outweighs the public interest served by disclosure of the record. A response to a written request for inspection of or copies of public records that includes a determination that the request is denied in whole or in part shall be in writing. So they can't just call you and say no, they have to put it in writing. This chapter does not allow limitations on access to a public record based upon the purpose for which the record is being requested, if the record is otherwise subject to disclosure. So they can't limit access depending on your purpose. So they can't say, oh, you have to be the person involved. So apparently they really can't ask you, if it's a public record, they can't really ask you why you want it. Okay, if it's subject to disclosure. Any person may institute proceedings for injunctive relief or declarative relief or writ of mandate in any court of competent jurisdiction, like that, competent jurisdiction, to enforce his or her right to inspect or to receive a copy of any public record or class of public records under this chapter. So if they won't give it to you, you can sue them. And if you win, the court shall award court costs and reasonable attorney fees to the plaintiff, should the plaintiff prevail in litigation filed pursuant to this section. You still gotta pony up the money, though, I guess, first. Coming down. This one I found really interesting. Unless you're a computer nerd, you may not. In implementing this chapter, each local agency, except a local educational agency, so schools, shall create a catalog of enterprise systems. The catalog shall be made publicly available upon request in the office of the person or officer designated by the agency's legislative body. The catalog shall be posted in a prominent location on the local agency's internet website. If the agency has an internet website, the catalog shall disclose a list of the enterprise systems utilized by the agency, and for each system shall also disclose all of the following. So as a computer guy, this to me means all these enterprise systems, except for schools, that agencies use, they have to have a catalog of them. If they have a website, it shall be posted to the website. Remember that? Shall. And the enterprise system for each system shall disclose all the following: a purpose of the statement of the system's purpose. To me, I really keyed in on this one. A general description of categories or types of data. So to me, that tells you if you got to know a database, and mostly these are going to be database systems. Everything back end, any kind of computer program nowadays got a database tied to it. So if you know the types of data, you know what they're gathering, you know what you can ask for in your requests. So that's big. If that can help you out a lot. Just my 2 cents. There's a 911 services. And it says the local agency shall complete and post the catalog required by this section by July 1st, 2016, and thereafter shall update the catalog annually. I didn't see anything on the Ventura County Sheriff's Department website. So, I'll look into that more. That's it. So this is going to be chapter 0. And next, I'm going to talk about the laws that are to come next year. So there's some new stuff coming on California Public Records Act. So that'll be chapter 0.5. Thanks for listening and watching too.